All right, and good afternoon for our second convening. And I'll give a spoiler alert. There will be at least one more, a third. So I'm going to jump to that. And I sent out an agenda. It went out a little late. But November 12th, we're going to meet again just so that we can make sure we're on track and perhaps have more. I'm just kind of letting folks know that for certain we will have this additional one. And that will be at 1:30 again on a Tuesday. It'll be in this room again. We'll broadcast it. And while we'll be talking about the issues that we're here to address, I am going to have a bit of a detour in that one. And I think it's important. We just did a CLE yesterday on special action rules. They are changing. And as of December 31st, they will be very different. And they include two provisions that are particularly relevant to the group here, and it seemed like a good way to get the information out to the group. And that is under Rule 12, there is now a provision that says the court should take special action review, grant jurisdiction, if it involves the life or health and matters of a child, and also if there won't be a full and meaningful opportunity to seek review on appeal. Where that comes into play, and I think most folks in the room have understood this, and we have struggled to figure it out for dependency. How do you get a meaningful review of a dependency ruling when the traditional appeal route takes 9 to 11 months? And at that point, there have already been hearings that have reaffirmed findings. We recently had a decision called GK in which we said, if you get to that next hearing before we rule, your appeal is moot, which means there was no opportunity to review that. So we're going to talk about, one, we're looking at how do we get those through. I started this process actually last year. I supported that provision in the special action provisions because I think if you're in a dependency and you need that review faster, it's an opportunity to get it in front of the Court of Appeals in a faster fashion. So we are going to talk about that, how that process works, how it's changed a little bit. But for you folks, in case you need to look at it, because it may be an appeal is appropriate for some, but probably not for most. I think that's something that we recognize, folks in the room probably recognize that challenge with dependency reviews. So I am going to, again, take that on a little bit of a detour. It is not the disclosure issue at all, but we need to think about that, and it just seemed like the right place to get that information out and to take that time at those because we have the right people watching online, paying attention to what's going on, and to get the information out about that new rule that may become important. So, having taken us off track a little bit, I just want to welcome everybody again. Thank you for being here. I'm glad that we're going to do this because I think we're making progress. I think we've already seen some progress. My understanding is that a number of judges, at least in Division 1, who have appeals, have had hearings set. I understand Maricopa County has a 2-week schedule, kind of tracking what we're doing, asking for the status in cases to find out what's going on. As we learned the last time, DCS was current with making the disclosure, and as a general rule, absolutely perfect, like everyone, I can promise, I'm not asking that, but as a general rule, we are current, or they are current with the disclosure. What I want to do is get a little bit of an update from DCS and the AG on where things stand. On the agenda, then we're going to hear from, start with DCS, then from the Attorney General, and then from Judge Foster on kind of where things are at. One of the things that I put on the agenda for today is to get into the meat and potatoes of it. There was a list that was distributed to some folks got it, and if you didn't, we can get it to you. But a list of the documents that DCS creates. And what those documents are, we can talk about it. We can talk about what are important and not important to have the actual copy, to have notice of the copy, what it is that needs to happen. And then we have the much longer list of the data points. Many of the data points are not things that would be important. We know that because it could be data points are just that. There are a lot of things that are just not relevant to disclosure, to even how the cases function. It's just how the system functions. But some of them are important, and which of those data points are and which of those data points are. So Judge Young is on. I'm not sure if Judge Starring was able to make it today, but Judge Young, did you want to add anything before we get started with hearing from folks?
I didn't have anything for today. Thank you, Judge.
Thank you. All right, so why don't I start with Ms. Patak? Kind of an update. I know one of the things that had been brought up, and there was a discussion about talking, was on things such as the redaction and things like that. And just an update on where we're at as we get started here today.
Sure. Thank you, Judge. Good morning. Or no, it's afternoon. Good afternoon. I'm sorry. I did want to say I brought a couple of people with me from the department who are the subject matter experts. So we have Christy Shelton. She is our Assistant Director for Field. And then I have Stephen Hinsey, who is our Chief Data and Product Officer. So he is doing all the Guardian stuff. He knows everything there is to know about Guardian, so he can answer those questions, including redaction.
My condolences.
Yeah. No, they won a bunch of awards for, a lot of the field side of it. It's pretty neat. So I don't have a ton of updates to give you. We're still plugging along. We are keeping a very close eye on the records unit because what we're seeing from field behavior is as cases are coming up, they're redisclosing a lot of stuff because I think they're like, well, I'm not sure if it's this or that. It takes a lot less time to just give everything again than it does to go through it. So they are, right now they said they have 107 requests with page counts between 200 and 10,000 pages and 34 with page counts from 500 to 10,000. So they're getting a huge influx of documents, so we're keeping a very close eye on that. We need to re-engage the redaction company. We're going to re-engage the redaction company. We have gone through many of, I can talk about the ones at issue in the order, right? Okay, so we've gone through many of those. So it looks like we've done about, these numbers aren't statewide, so I'm not going to give them. But they're in Maricopa County, we have a team of 11 people who are getting overtime to do these. In the outlying counties, we have somebody in each office who's assigned to them because they have to sometimes go to the courthouse and actually look at the file. So they're going through those. We've worked with IT to pull the emails, so we make sure we have all the emails as far as that goes, and I think it's going well.
And my understanding, at least, is that Maricopa County is meeting every other week to get an update and find out what's going on. How is that process working? My understanding is, and I don't want to overspeak beyond what is public record, that at that hearing, DCS indicated that basically a case a day, at least of the appeals or something along those lines, and maybe I misunderstood. So if you can give, and if it's somebody else who has to give it, that's fine.
Kirsten is saying a case a week, but I was going to say from my team's perspective, we have 11 people working on it in Maricopa County, and our expectation for them is that they each get a case on a week.
Which is 11 cases
11 cases a week, yes.
It's not like, yeah.
Is that correct?
Yeah,
okay.
Correct.
I was not at the status hearing.
Originally, they had said one case a week with the 11 people, that it would just be one case a week, but we're seeing that they are processing those more quickly than we had expected.
Yeah.
Okay.
Yeah.
That's helpful.
Yes.
Did you have anything more?
That's what I had, unless people have specific questions.
Did you get a chance to talk about the disclosure? Because we had identified a case, at least one, just, doing the war stories of 300 pages of redaction, including the page number. Have you started to look into that? Apparent, I'm not going to say it is, but apparent over redaction.
I don't think I got the information on that, so we'll connect after.
Okay, let's make sure we don't lose sight of that.
Sure, yeah.
I've got a pin in that because I think that's an important piece. Judge Foster, did you want to comment on that?
Just a question. Kristen, there was a timeline on those 11 folks that were working at one point in time that they had estimated 5 weeks to finish. Is that still the situation?
Correct, and we're seeing that they are moving much more quickly than that. So from our end, the CRCU is pulling the documents, and they're sending the unredacted documents to our office. Andrea Kalmura is in charge of this project, and so she is doing the redaction. And then what is taking some time is our office has subpoenaed records. So we are looking at the records that we subpoenaed, and we are then looking at the records the department has sent us, and verifying that they are identical. So the department might say, we found 35 documents that we do not think were disclosed, but we're showing sort of the names are the same of documents that we had subpoenaed, but in order to ensure that they actually were disclosed, we have to look page by page by page. So that is what's taking the significant time, is going through these hundreds and hundreds of pages and trying to make sure that every single document was disclosed. If they're not disclosed, then our office is disclosing those. So we don't want to slow anything down, and CRCU is getting, pulling all of these documents, so that's why we're taking on the redaction of those specific documents ourselves, to try to move things more quickly. There was a meeting in Maricopa County, or a hearing in Maricopa County. I think there were 31 cases that were discussed with Judge Bustamante, and all of the parties were on for that. They reset the hearing. Andy, do you remember? November 1st is the next hearing with regard to the Maricopa County Court of Appeals cases. We are desperately trying to move them through as quickly as possible, but we want to make sure that, especially with the requirement of the affidavit by CRCU, and the avowal by the Attorney General's office, we need to ensure that we aren't making any false, statements to the court. So that is why we're spending so much time diligently reviewing the documents. Other than that, we've gone through the data list that the department provided us, and we spent some time with Stephen, who is very knowledgeable in this area, and went through sort of some of the titles of documents that we weren't really sure what they meant, and so he explained to us what those meant. So the Attorney General's office has reviewed these. We've kind of color-coded the types of documents that we think, as soon as we receive them, we'll try to get them out within the 10 days. And then there's a second set of documents that might be something that gets generated sort of monthly rather than within the 10 days. Obviously, we need to have a conversation about it. And then the third set of documents are documents that aren't produced in every single case. So we would ask that those more be on a case-by-case basis. If your case has something that would pertain to the orange-colored documents, that those are documents that we would get out upon request. That is how we have looked at it. The goal is still to get every single piece of information out to the Defense Bar and Children's Council as soon as possible within the time frames. I have briefly looked at the electronic discovery rules with in the Arizona Civil Rules, as Mr. Foster had recommended. I'm not sure that they would make a big difference, other than the department could certainly assert a burdensome argument with regard to some of the items like case notes case notes we're fixing, but emails it's very difficult for the department to pull those all in. As we've seen, they've tried 2 different ways to get us the emails in order to disclose those, and you're having to convert every single one into a PDF, send that PDF, redact that PDF. Some things, it's normal for a case manager to put the placement's name and information in an email when they're sending it to Children's Council or someone else, and so those have to be very carefully reviewed to make sure that we're not sitting out at any confidential information.
Disclosure is done, and the judge below and the attorney and the parties below could say yes or no, it's effective.
There are a handful. I think we are moving more quickly in the non-Maricopa counties, in the counties that are in Division 1, and that is mostly due to caseload. Their caseloads are smaller, and so they are able to review their documents, I think, more quickly. I don't know if we want to have Ms. Kawamura come and sit up so that she could,
And I'm going to, while she's coming up, I'm going to just restate the question because I didn't hit the button. My question was, so the folks in the room and perhaps online can hear, is whether or not the hearings on the actual substance of the disclosure. In other words, the disclosure happens and then the judge and the parties below have to look at that and say, do they think it made a difference or might have made a difference, and are more hearings required? And so we just heard that it's moving. A few of the cases have started to get to that next phase. And do we have a sense of when we'll get through that phase?
So in Maricopa County, we have completed 2, where we've gone back to the court and said this is the information that we need to be able to provide, and so there are 2 that should be coming back your way fairly soon. And the other ones, we are just waiting to get through that redaction and disclosure process.
We're in the middle. Andrea Kalamura, with the AG's office, and we are filing today one in La Paz, one in Yuma. There's one in Yavapai where there was a hearing yesterday, and we are in the process of filing those affidavits in that case.
I appreciate it. Judge Foster, anybody on your side who would like to give an update, provide any other information that you think is relevant to get moving here today?
Okay, thank you. Judge Goss, Judge Young, panel members. Kind of a misnomer, I guess I'm here to speak on behalf of, in part, on behalf of the Indigent Defense Bar. But given the nature of our various practices, it's not like I can speak in a united voice on every issue. I just want to make sure
And I
everybody
just want to, I appreciate that, and that's a perfectly appropriate disclaimer. I don't think anyone can speak on behalf of anyone else.
Yeah. I think when we were here last, we talked about how to move forward with on current cases. The remand cases are what they are, and until the documents come out, there's not much we can really do about that. But with respect to the current cases, this issue with respect to disclosures, it's a large one, it's a huge one, and in particular, given the revelation that there was this culture of non-disclosure, and the notion that we want to get to some sort of agreements, we're kind of in a boondoggle. And the boondoggle is hard to agree to things that you don't know. DCS, the AG, has sent us a list of categories of documents. I've got about 3 different lists, and I'm still trying to decipher them, and I think we're going to have to meet so that we figure that out. This one that we got today seems to be a little different from the one I got a couple of days ago. But in any event, there are 420 categories, 419, I guess, at least of the document that I got. And in reviewing them, I was able to determine, I think, with some reasonable understanding what the document was, but there are others that we still don't know. Once again, that can only be resolved to the extent that we talk to your representatives and figure out what those things are. The idea was to try to get to a baseline of documents that we feel should be automatically disclosed, and there's been an attempt to do that. But even then, I think it's important to understand that even with that baseline, other documents that can come up that should be disclosed without having to make a particular a request for them. I know it was reported to me that one of the judges is saying, why don't the attorneys just ask for the documents that they need? Back up and say, you can't ask for what you don't know. Okay. So when I got this list and was able to, like I said, identify what certain documents are, for example, what I was not able to understand, and perhaps somebody can tell me, of these 420 categories of documents, which are the culture documents, if they're on that list. If they're not on that list, once again, it's something we don't know. And I think we need to know. It was mentioned about the electronic discovery, and that rule is kind of a guidepost as to where we want to go with this. And it requires the parties to meet and confer. I will tell you, in my years on the bench, and even before that, any committee that I was on where somebody had a rule change requiring lawyers to meet and confer, all heck broke out. Nobody wants to meet and confer. I still can't understand. It doesn't make sense. It seems to me that you can resolve a lot of things with a meet and confer. And I think I'm in the minority in that position. But nevertheless, I'm willing to meet and confer to get clarity on the identification of the documents in the list, what documents are culture documents or not culture documents, to resolve, to the extent it can be resolved, what the agency and the AG feels are discoverable, what they feel or disclosable, and resolve those questions as easily as we can. I mean, ultimately, once again, you know, last time we were here, we talked about we want all of it, but we want all of what we're required to get under the law. That's our point, and we want to really knock that point home. And nothing in these lists can be the be-all and end-all of what the responsibility is. It doesn't work that way. The ultimate resolution of some of these things can really only be done on a case-by-case basis in the trial court. And because as we sit here today, I don't think we can think of every type of document or data point. And I'd like for somebody to define data point before we leave here today, you know, because, you know, for old guys like you and me, Judge Goss, we didn't attend school with a computer. And I find that sometimes we get bound up or confused in the technology. So, and you know, and what's in those data points sometimes, well, it may not be salient on one side of the V, it's quite salient on the other. So, understanding what those things are, what they represent, and knowing whether or not they're going to be relevant to our case, it's important for us to meet and resolve that issue. So, there was a mention of case notes, and I guess visitation notes falls into that category. When I reviewed the list, I didn't understand that those were on the list someplace. I think we discussed that those were things that were difficult to pull together, but again, those case notes, visitation notes, emails, texts to the extent that they're still existent, are things that can become important to a case. Before I stopped appearing in court, I had a couple of cases where emails and texts were critical to the resolution. You know, in light of the spirit of the rule and getting together and talking about these things, figuring out what you can produce, what you can't produce, I think Katie talked about last time. Your screen, a referral is basically an electronic entry. Okay. And how do you produce those? And you said talked about a screenshot, or perhaps there was some other way to make a summary. I just need to get with them more clear so I can explain to everybody else, you know, how we can get those sorts of things quickly.
Judge Goss, your microphone is off.
I'm sorry, thank you. I think what I want to do here today is actually have us start that dialogue. Let's start to go through. And I am going to start with, I again agree that we're not going to resolve disclosure in all cases for all time because it's impossible. Each case is a little different. A document may be likely to lead to discoverable information in one and would be of no use in another. There are some documents that have to be disclosed in every case that I don't think there'd be any disagreement. What I understand is the ones in the green are the department even says, hey, in every case we need to give these, maybe even in a redacted form, but they need to be there. And I don't think at this point the emails or the case notes, and there may be other things that aren't here. And so legitimately, what other things aren't listed here that are probably relevant that, again, as the line is appropriate, we don't know what we don't know. So if we could start to do that, and I think that's probably the data points piece. It's data points that not actual documents created, but other information in a data point. So why don't we start, because of the question, with what is a data point? Why aren't emails and case notes in here? Because they are documents that are in fact created. And then are there other documents and how? So whoever wants to take the lead, and I'm getting the impression it is the IT guy.
Yes,
Give us your name so
thank
that we
you,
know who you are.
Stephen Hinseed, Chief Data and Product Officer for DCS, over our CWIS system, which is Guardian, and all of our data and reporting and some other areas. So a big batch of very good people that work for me. Which points would you like to hit first, so I can clarify?
Why don't we start with what is a data point? Because I think that's a global issue, and it may identify
Fair.
some of the reasons something's not a document, it's actually a data point. Because we will be going through the list of documents, we'll be going through the list of data points.
Absolutely. So we have a document management system that's called OnBase that is part of our CWIS application. The items that are stored in there are what people would call documents. PDFs, those are things that are uploaded from providers. Everything that's on that list is considered a document in there. Currently, the application has the capability of disclosing 100% of those and timestamping them. So that functionality exists today. There's no restriction that prevents people from doing that. It packages up very nicely and allows for people to redact it from there. So from the document side, if you were to ask the question, is there 100% of information disclosable and trackable? Yes, is the answer to that. Now, there is the operation side of that. Is it happening from the manpower side? And that's a different question that I don't have an answer to, but I know that there's reporting and monitoring happening on those things. So hopefully that answers the documents.
Well, let me ask, because, for example, a document that's created in legal language is
Right.
a case note. But that's not a document in Guardian, but it's all created in Guardian. So
Right.
why is that different and how?
Sure. So a document storage system like OnBase takes things like PDFs and uploads those as images. A note that is entered into the system is stored in a table. So just think Excel spreadsheets. So a case note is stored in a table inside of our CWIS system called DCS notes. That single table has every investigation note in it and every case note in it. That includes the home visits with children. It includes some notes around coordinating visits and a whole bunch of other things that a case manager is doing in their day-to-day jobs. When this issue was first brought about, it was focused on those documents from providers, like parenting time and visits. So we went head first at solving that issue, and we fixed that one.
And is it fair to say what you're calling documents then are the external documents, the things that came from someone else that were created? Are there any DCS created
There are,
PDFs?
yes. There recently was a change in some of our supervision processes that no longer has a PDF created, but there were some administrative documents that are uploaded into that system that are also disclosable and trackable in the system. So there are both items from contracted providers that they upload through a portal, and there's also information that our employees upload directly within our system as PDFs. So an example of somebody providing a picture in an investigation, like they would upload one-off pictures.
So a document, you said that some of them aren't being turned into PDFs anymore. What happens
Correct.
to them, because they may be documents that they need?
Yes. So we do have functionality in our system to export data as spreadsheets. So you can still receive the information, but the mechanism of delivery is less dependent on packaging in a PDF, a specific technology. In the long run, this is going to be a benefit, I think, when we start talking about the automated redaction of things. If you were to go down the path of trying to automate redaction on PDFs, there's a lot of jumps you have to make from technology to make that a reality. But if you're moving from data that we can store in a structured and unstructured way, you can use some more advanced tools to try to do selective redaction and things like that.
So in the world of I don't know what I don't know,
Correct.
and I'm going to give you folks a chance to ask questions, but I'm asking ones that I'm curious about. How do they know that that data is there to even want to, especially now it's not even a document that's listed here?
Fair. So there was a sheet with about 1,800 tables within the CWIS system that are not documents in the on-base system. Now, the ones that most people are going to ask about are around the service delivery, around family functioning assessments, or around the investigation notes, or some safety plans, things like that. Those documents, we have them, and we would likely be able to present it in a way of the volumes of data that are stored. So, an example of this is DCS Notes is our highest volume of data that's stored in the system. And reasonable assumption, and obviously we would need to think through this on how you determine what's relevant, but the highest volume of data being stored is likely a relevant piece of information that you want to know, because that's the narrative text that someone's typing into the system, and it's expensive to store that stuff. So we're able to pull some data on that. We can start there. Now, the things that you probably would not be interested in are some of the really back-end system tables that are showing when a user logs into the system and how many times they logged into the system. You don't need that for a case, although it would be associated somehow with the case.
So what would be, is that list something, because that's a list I think they're going to want to look at. I don't know
Yes.
that I've seen that list. So I think we've got another list. Are there other things like that? And I'm just, you're the tech guy that you go, well,
Sure.
we can generate this, we can generate this report. Is there another piece? Because I don't think this table concept was there.
Right.
Anything
yeah.
else like that?
So I think you've already hit on some of them already with the emails and text messages are probably the other sources of data that we would need to try to pull together. I think identifying is actually probably going to be the easier option. It will take time because we'll have to sit together and talk through it and work through that list. Getting all the information collected into one space to be able to package it up nicely is a technical spider web that can get hairy. It is not impossible, and it's on our roadmap to do this. We do have an ask for some additional funding. We're working with the governor's office to try to speed that up. But if that falls through for whatever reason, it just means the timeline stretches. So we
Or it
continue
doesn't.
going. Or it doesn't. Very fair.
And I think that's part of it, because we've already had a year.
Yeah.
And so, why don't we, I want to give you folks a chance to ask some questions, follow up, because I think we've already gotten some more information that merits follow up. Do you have anything, Judge Foster, or any of you folks?
During our last hearing, we had an email from someone in All County or Pima County who is a computer tech person who is monitoring our new system, which is called June A, who indicated to me that he is aware of some way of how to do this because new systems are built on a similar platform for storing information, retrieving information, and that sort of thing. So I will try to find that, and perhaps we can talk about that as well. But I appreciate the explanation regarding the on-base versus the other proprietary stuff that you mentioned. Do you have
Sorry,
a
Judge, he did reach out to us as well, and we have a meeting with him, I think, not tomorrow, the next day. Yeah, in 2 days.
Okay.
So appreciate that.
Do you have a brother that's an attorney?
I do. I've got a couple, yes.
Okay. I was gonna say, well, the resemblance is
And Stephen came from the field, too, so he has the field perspective as well, which I think is super helpful.
all right. Thank you.
What's your last name again?
Hinsey.
I thought,
You may know a Michael or a David or a Timothy. Or a Greg.
Just don't
Sir?
say toit. Inside joke, I'm sorry.
Bill Owsley, the Office of Legal Advocate. Real quick, you talked about the 100% of the documents that are in Guardian, I think currently. PDFs or spreadsheets are disclosable and trackable at this point. So when you say that, can you define what you mean by disclosable and trackable? So you can disclose all of those immediately, and then when you say trackable, you'll know exactly what documents you've disclosed, and the system is able to keep track of that so that you know 3 months later you're staying on top of it, disclosing on a consistent basis, just so that I'm clear about those. And then
Yes.
what falls out, again, you did talk about the spreadsheets, and it's a little bit different,
Right.
but are you talking about all of the documents, the notes, everything? Are all of those disclosable and trackable from your?
So, the disclosable trackable is anything that is in our on-base system. So it's those uploaded PDFs or other documents or things that some people will call artifacts. When those are disclosed, it creates something called a disclosure packet within our system that has a unique identifier, and it's time-stamped, so we can know that that's something that was that completed the actions that are required to disclose. The caveat with this is that because our system doesn't talk directly with the 15 counties and their systems, there is an assumption being made there that a human is actually sending the documents, right? Because it's not automated receipt by the courts, so that's the one caveat I would give. But in our standard work, if someone goes through building this process in the packet, when that finalized date is on there, our processes line up that is something you would consider disclosed and tracked, and you could go back and question it later and find emails or uploads into JAX or things like that to validate. Now, that does not include information in Dynamics yet. We are currently in development of the next phase. We'll start pulling in some of these data tables into the same disclosure transaction log that will timestamp when it was disclosed and how many times a thing was disclosed and in what matters was it disclosed. So these are things that are currently on the roadmap to build out but are not done yet.
You're talking about when you say these data sheets or data tables, it's every one of these that's in this packet?
These are the on-base documents, so those are
Every single one of these is in on-base?
correct, yes.
Okay. And just to comment briefly, I know that there's been a lot of discussion about, going through the list, and, there's three of us sitting here, and there's hundreds of, defense lawyers that do this work and offices that do this work, and you're going to have a disagreement on a lot of the, what I believe is relevant versus not relevant. We've had discussions ourselves about this. At the end of the day, the responsibility lies with the agency and with the Attorney General's office to disclose that stuff. So I think the conversations are appropriate. I would tell you that every single one of these should be green. That's my perspective. There are lots of these that are yellow that I want all the time, and I don't get. I've never gotten, I think maybe twice, and a lot of even the ones that are orange, I know you mentioned, Kirsten, about having these documents being requested if we believe it's an issue in a case that we have. And again, like George mentioned, and we've said over and over, we don't know whether or not those documents have been created, if they exist. And so again, at the end of the day, I think the discussion can be beneficial for everybody once you understand what we think is relevant from, and there are probably lots of us that want to sit in on that type of a discussion. Makes it easier for the department and the agency to say, yeah, maybe we should be disclosing all of this stuff because, it's not so simple, what you think is relevant. And again, if all of these are in the system and they're all disclosable and trackable, and again, I think that there are probably very few things that we can agree to that I don't want. I don't need to, your licensing agreement with Microsoft or whatever it is that you keep in your system, but I want everything else. I mean, that's kind of where we're at. So I think it's a good discussion to have. I just don't think we're ever going to get to a point where we say, yeah, I agree. On very few things we might. But.
And Bill, I totally agree with that to a significant extent, and I've always used referrals as my example. If the referral goes in and everyone's happy and the parent does a service and the referral gets closed out, the referral never becomes an issue. But when you have a parent who says, I've been asking over and over and over again for a referral to go in, that referral date that goes in becomes extremely relevant to the case. So it is such a fluctuating system that we operate in that many things may never become relevant, and yet some very tiny piece of paper can be the crux of a whole case. So I get that. So I think the relevant issue is going to be less of significant. I think we are going to agree that any document can become relevant at any point in time. I think it's more a time frame. We don't need to disclose these, but maybe more a time frame issue. And as I mentioned last time I was here, last month, the department created over 88,000 case notes. That's a significant, just those case notes alone is a dramatic number of documents that need to go out and be disclosed. So I think it's more the time frame piece, more rather than worrying about the specific documents and what should and shouldn't be disclosed. We agree that everything that that could ever become relevant needs to go out there. It's allowing the department to be able to do that in a manner that is the least burdensome and the most cost-effective, as the rule provides.
And I understand what you're saying, that, that you want to, try to get as many documents out as you can, the ones that you think are clearly relevant, all the time. Those should go out as quick as possible. Again, from my perspective, all of it's relevant all the time. And so for referral, going back to your example, if the department's made like 3 referrals, and if you don't know that because nobody's looking to see how many referrals went in or didn't ever go in, you're never going to think it's relevant. I may look at that and at first glance say it was 6 months late. It's relevant to me. It was relevant immediately. But to have to look at every one of these documents on a case-by-case basis and say, well, it's relevant here, it's not relevant here, the timing is relevant, again, it may be something that, again, it's way too difficult to pay attention on especially if Line's doing any of it, or even the Attorney General's to understand if it's an issue in a case. And I may not know that until I see it. And so for me, again, it just is so much more simple to say, however this gets disclosed, it just needs to happen all the time. And it can't be, again, I looked at a lot of these documents that have, like all the education records that have to do with my clients. I want that all the time. There's a ton of issues that I have with my clients dealing with their education, special needs stuff, IEPs, that I'm involved in. I don't get those documents. And for me to say, well, every 30 days is fine, that's probably not okay. And I would never say that. I would want it within, if you got an IEP, I would want that immediately, within 10 days. And I think that the parents would be entitled to that as well, and would make the same argument. So I think it's important to have that discussion about what we think is relevant. But again, for me, it's a really broad net because I don't know what's relevant until I actually take a look at it. And I know the case well enough.
I want to jump in because I want to go back to the standard for disclosure, which isn't relevance, but it is in fact likely to lead to relevant information or stands a reasonable possibility, and any referral could be that. What if the referral was wrong, didn't have the right information or something, misspelled a name so the person never got checked in the way they should have? So I want to work with the standard of likely to lead to relevant information, not relevant, because we're not going to decide what's relevant. That definitely is case by case. The second part, and he's going to be in front of you, Judge Foster, I'm sorry, and I don't know your name, so I'll let you do that in a moment. So I just want to focus on that standard. And I think, again, and this is Merritt's mentioned right now, what we have is a history where there was a real pushback on any disclosure. We now are in a place where there is not that pushback, which is a valuable thing. And I appreciate the AG and the department stepping up and saying, we have not done this the way we really should have. So what we want to do is get to that point. What I want to do at some point is look at these and talk, because I can see places where, and I'll just go to the first orange one, proposed substantiated findings. I don't think you're going to get their proposed findings. You're going to get the ones that they send you, but not the ones they propose unless it's part of a discussion back and forth. So there are some things on this list that I can see that are not going to be disclosed for good reason, because they're not appropriate for disclosure under any circumstance. So that's why I think we need to spend some time on this list. And I think some of that will happen offline, but I want some of it to start today, because I want to, if we don't get it started, it doesn't seem to gel. But that's what I want when we come back in 2 weeks. How much progress did we make on these lists? And I need to know the OnBase system and the change in the computer program to be able to pull the things in through OnBase, what that timeline is, because what I talked about the last time is deliverables. So why don't we jump to you, sir? I'll let you introduce yourself, and I'm happy to meet you. We may have met before, and I apologize if that's the case.
It's a pleasure, Your Honor. My name is Seth Draper from Office of the Public Advocate. I just had some questions about the tables and these data points we're talking about, because I just was hoping maybe you could provide some clarification. When you pull this table, is it usable by a person? So if it does generate like an Excel spreadsheet, I understand that that's probably what Guardian does, right? It makes that usable. Are we just going to get 1,000 rows and 1,000 columns of condensed, odd language that isn't very scrutable? Because I know it's a pain to convert case notes into PDFs, but when I get those, it's readable. I can look at that in a human language, and I don't need to train someone to how to understand that. Versus a spreadsheet like that, I don't know that that's helpful. And I guess that's also a discussion, because again, as we're talking about the electronic discovery, there is something of a burden. I know we're not normally in civil, but we are civil practice, and we can get to those rules for discovery sometimes. And you know, that is a goal, right? We're trying to make it. It is a burden, and I'll agree, it is a big burden to DCS. But it's a big burden to everyone that does civil litigation, right? Freezing tapes, making copies, making things word searchable are routinely done in civil litigation, and that's what we're doing here. You know, so to that extent, like, I don't want to say it's not a burden, but also getting us a table that isn't necessarily readable or understandable to anyone isn't helpful to that end.
So a couple things. On the conversation about the documents and going back through the list, I just want to share just a downflow impact of that. So if we go back and say we're going to do less than 100% when we've already finished that solution, then we have to go back and rework that solution. So we need to spend some more time, effort, energy in doing that. So just food for thought as we move forward on this, that the printed list here
is 100% easier?
100% is absolutely easier, yeah.
Okay.
And that part is done. Now, easier comes with a caveat of the redaction side. You may need to spend more time and effort redacting things. So from extraction of a system, 100% is always easier. Redacting is where you pick up some of that lift.
But for example, on this list are things like PSRT findings. If you're going through the dependency
Okay.
process,
You're
then they
going to
won't
have
be
to
on there.
unpack that for everybody in the room. What is PSRT findings?
So if a person is proposed for substantiation and they're going on the central registry, they will get a finding that says or a letter that says your case is being proposed for substantiation. If there is a dependency finding in juvenile court, that finding automatically is considered a substantiation and goes on to the registry. So rarely will a parent get, as it stands now, in the past they would get the letter, but now they're not getting the letter from the PSRT that says you've been proposed for substantiation. So those are documents that would be, they could be from like a past referral, say a call came in, the department investigated, didn't remove the kids, but they may have proposed it for substantiation. So there might be a document that's old that would be in the system, but that wouldn't necessarily be something that would go out in this particular case. So there are, even though 100% might be easier, there are documents on this list that should not go out, if that makes sense. So that's where we need to really kind of refine the list so that the department knows exactly what is supposed to go out, because there's licensing information. So the licensing information for placement, that should not go out to the attorneys. Those are the types of documents that are included in the 100%, but that would not be considered relevant documents in a specific dependency or severance matter.
But as a category of documents, we can at least reach that idea. There may be a case then where discovery is more appropriate because it's not something that's normal because of that. But what I want to come away from this with is the area where we go 100% disclosable, should be disclosed. If there's a disagreement between between folks, we're going to have to leave that to the trial courts. That's where that rests. That's how we settle it, and it'll be a case-by-case resolution. But there's globally a lot that we can say just needs to be disclosed, and that's what I want to get. What is the universe of stuff where there's no disagreement and it needs to go, and how do we get there? And it may be that letter, because I don't know that these folks won't say, look, a referral from 10 years ago is a big deal because it's consistent with or it's inconsistent with what the current report is. So that's, I guess what we need to do is start with what I want is what's the big fish? What is the thing that we go, all of this in this circle is going to be disclosed, and we're going to disclose it in a usable way. And that's why we have to fight through the yellow and the orange. If there is something in the yellow and orange where there's disagreement, then I'm afraid that is back to how we handle it. We litigate it, but what you do walk away from this is knowing that these things exist and that it may be something you need to litigate if we can't come to an agreement. But I think we've got most people in the room working towards an agreement. So that's why we have to go through the devil in the details. What are these documents? What are the data points?
And if
Can you unpack the data points still a little more then? So go ahead and.
Yes, if I may, because I know I didn't answer your question yet on the spreadsheets. The on-base point, I think everybody can grasp that one a lot easier than the dynamics side of the application. So the dynamics side is what everybody knows of as Guardian. It makes things look pretty for people typing stuff in the system, right? All that information is stored inside tables that are related in a very complicated data map, but it makes the system function well. If someone is exporting the case notes from the system, it does come out in an Excel format native CSV file. You could Control F and search all day in that file without having to have special software for like Adobe OCR scanning or other things that are needed in the PDF side. But then generally security teams are also going to have some questions about that. Can you modify our data and then change some of the information that was sent to you? So there's some additional like security controls we'll have to put on it to make sure that people can't modify or that you have some traceability. So then thinking through like, am I going to see things that are unusable to me? Yes, you will. Like, you won't care about a checksum value for a record. But that's absolutely important for the integrity of data that we're sharing, is that we retain the checksum, we retain the unique identifiers, we retain modified dates, things like that, so that we know that that data that we're both looking at is the exact same data and no one can question that. There are a lot of other fields that are going to relate to that note that when you export it, it'll have a unique identifier for a case, it'll have a unique identifier for an assessment, for a person, and some other metadata about who created the note, when did they create the note, when did the event date happen. So yes, an Excel sheet will have more columns than you're used to, but it will also contain the data that you need in narrative format that you can read a big block of text just like you can in those current versions of things that are extra work to do. Now, what I will share is what was attempted in the past with our previous vendor and in trying to solve this disclosure process was taking things from that Excel format and pushing it into OnBase to make it pretty for folks. There was a lot of money sunk on that did not turn out. We got money back from Microsoft and they bailed after a year. So that's the risk that I don't want to go down again, is let's figure out like how do we get the information collected to a space that is usable, and then once we get it functioning well, we can say, do we need to pare back some things because an extra column is not actually necessary. But in what we're approaching here, like we have to think about the necessities as opposed to the nice to haves and make sure that we're like laser focused on what's the necessity to get the information to people as fast as possible. And then let's worry about what it looks like when you print it out. Printing it out is not necessary in any of these functions anymore, but searching it on a computer to find the relevant information you need should be absolutely part of this.
And would it be possible, it seems to be, and I understand the integrity, believe me, with all the work we're doing in artificial intelligence, the possibility of altering documents and altering photographs and everything. With regard to, for example, this spreadsheet that has columns that really aren't relevant to anybody unless you're looking at the integrity of the document, that they could be hidden columns so that folks over there don't have to have 7 columns that are just in the way. It's just hidden, but you can unhide them if you decided it was relevant. And then again, that the document itself could be locked in a way that can't be altered.
Generally, yes, this would be the theory on how we try to solve it. And as we're going through this next step, it's actually probably one of the more important ones in the design is case notes is the first data table that we're going to disclose. So we need technologically to get it out in a way that makes sense, and then figuring out what's the readable format that people can use in a way that doesn't set up this money pit that we're always tossing at and chasing and never being successful. So I don't have an answer yet for how we do it, but I know that's what the team is tasked to do, and we're expecting a list of names this week so that we can start testing with the outputs to make sure that it meets the needs and isn't just like gibberish or just a bunch of waste of space for folks to use it.
Judge Gus.
Sure.
You know, we kind of talked about this last time, and we're, I guess, necessarily getting into the weeds about what it takes to get information out of the computer into our office. And that's all well and good. But I want everybody to remember, we're talking about kids being removed from a home. Okay? Hearing 5 days later, we're operating in the blind because we don't know anything except what's in a petition. Okay? We have very little ability to challenge that removal in a temporary custody hearing. And whatever weeds have to be cut down to be able to get us at least a preliminary information, what that investigation looked like, to the extent there are witnesses or somebody else that's able to testify as to what happened here. That's of primary importance. When we think about the trauma to children, when we think about the trauma to parents, when we think about other siblings and other family members that are going to be involved in this thing, timing is essential. Timing and substance is essential. I know we know the information is there. Get it to us. And get it to us timely. If we don't do that, the whole framework for this system is in the garbage. I mean, really. I mean, I'm talking about realities here. I'm not talking about, ones and zeros and X's and zeros. Okay? If you create a system that can't generate the documents within the time frames required by the law, then what good is it? And if it costs money to fix it, then you got to fix it. I don't know one civil judge that will sit on a case and say, okay, well, I got an antitrust case here, I got all these corporate documents, I got all the sales and connections and all this other stuff. But you can't produce it that way. Yes, you can. I don't know how to fix it. I've already pled ignorance as to many of these tech issues. I'm sorry. But all I know is if you want to put information and data in, you got to be able to get information and data out.
And I think we're working towards that. The one thing that I heard, and I want to make sure I unpack it correctly, is when we have a new petition, when we are looking at that dependency phase, and that's part of what I was talking about earlier, that there has to be some sort of triage on cases that are going to a temporary custody hearing to make sure that disclosure has happened, as opposed to maybe the ongoing, all the time disclosure. Is it fair to say that there is, not that all disclosure doesn't have to happen, it has to happen timely, I'm not saying that, but especially for those brand new cases where we know we're heading into temporary custody hearings and the children are being removed, and there is trauma that goes with that, that the attorneys for the parents have the data they need to walk into that custody hearing prepared as much as the AG. Is that a fair statement, Judge Foster? And do you want to unpack that a little more?
All of what goes into the removal decision, and I guess they're doing things today that they didn't do many years ago. You have the TDMs and all these other things that are going on. But you have the other cases where the removal is immediate because of the alleged danger. But that's the type of information we need to know as well. For an attorney to be able to say to a client, here's what they're saying, were there any witnesses that you know about, were there any family members, who can we bring in to testify for that? Or in domestic violence situation, who knows about your situation with this person that's about to kill you? And you can't get away from it for one reason or another, and it's really not your fault. Okay? That shouldn't have to wait for necessarily a dependency trial some 9 months down the road. There may be a solution that early in the case, but if we're in the dark about what the heck went on, we can't even present them.
I guess that was my point, that in the very beginning, there needs to be disclosure as quickly as possible, just so folks know what's happening and why. And then that's it. That's why I referenced the temporary custody, not the dependency finding, sure, because it's two different things, and we have children who have been removed. And so I think that's kind of a separate discussion, but relevant, is that timing of that first set of documents and information. In addition to then the everyday, how do we move these cases along? as they become 9 months, a year, and I think they're two different things. In a sense, not that they're not both disclosure, not that they're both important, but what may have to happen right up front is something we haven't really talked about and focused on.
And just for everyone's clarification, Mr. Foster raised that issue at the last meeting, and so we've spoken with the department. Ms. Shelton is brand new, so I know that she is working with her staff, I'm sure, to address that situation. But we agree, and as all of you know, I represented children and parents for 8 years. I truly understand the importance of having that information right away. The department understands that. I don't know if Ms. Patak wants to speak further on that, but it is something that we're addressing.
Well, and I appreciate you raising that, because I feel like that's an easier one for us to address, because it's like there's a smaller universe of documents that exist at that point. And so I think we can have that conversation. But
Just real quick, and I
I'm sorry.
appreciate that. So again, getting documents right up front goes a long way to talking to our clients and really being able to understand which direction the case is going and maybe where kids end up being placed. But at the end of the day, I'll go back and say the same thing. It doesn't really matter. The documents need to be disclosed within a certain amount of time. It's clearly a lot quicker at the beginning of the case than it is later. It's still 10 days. And so I don't want to get to a point where we're just saying, well, we need to triage, for lack of a better word, this case because it looks like things are kind of blowing up and we need to make sure we disclose it. I would tell you to not think along those lines, and that has to be disclosed constantly on a regular basis. I have cases all the time that I don't get any disclosure, and I have no idea what's going on. My client maybe says to me, I want to go home, I want to go home, I want to go home, and I say, and I keep having to call or beg or ask for information, or I should just get that information. I should just know that there's progress, and I should be able to file a motion, but sometimes it takes, weeks or months to get to a point where, I even have enough information to move on something. So it's relevant all the time for me. And so, again, I appreciate the effort to make sure that it's disclosed up front early and we don't skip that, but that we don't lose sight of the fact that, these cases are living and breathing cases. They don't it's not like a criminal case or a civil case where you got one set of facts and you just litigate it. These things clearly we're here on disclosure, which is just this monstrosity, but it just never ends. And it's super important for us to have this information on a regular basis, again, immediately, as soon as we can get it. 10 days is where we're at. And again, we can have the discussion about how we color code these and what it looks like and what's important, but really, it's going to come down to, again, there's going to be a lot of people. I'm not going to agree with what maybe George thinks is green or yellow, but as long as we have a pretty good feel, that's something we absolutely don't need. And I think that any lawyer sitting in that chair would say that, fine, those are the documents we can, those are the columns that we can strike and move along. But, there's still going to be a lot of information we disclosed. And again, it would be helpful at some point. We've talked about this, and I know at the last meeting, Katie and I talked about meeting and, going through Guardian. And I'd really love to know what every one of these documents potentially contains inside of those. Potentially, because I know some of them will be blank, and other cases there'll be a lot of information. So, and it generally would be relevant one way or the other. So I'd be curious to know, again, the details of all these stuff.
But I think that's what again, whether here in this room or, offline when you folks sit down, I think you need to do that. You need to go through every document. And triage may have been a poorly chosen word, but my point was that early in the case you need something right away so you at least can talk to your client about what's going on. And then, again, that's just recognizing there may be a slight difference in that from the other, but the disclosure is relevant or is necessary at all times and needs to follow the rules. So it was just me thinking, let's make sure we don't lose sight of what do folks need so that we say, hey, let's get this needs to get out the door right away when the case gets filed, and then keep it moving.
If I can just make one more point.
Sure.
Ms. Kawamura sat down and went through all of the forms that the department has. So, she printed them all out there in this big binder over here. So she has looked at every single one of those forms to see, okay, are these things that we need? Some of them are old from when DCS was CPS, so they're not documents that are used anymore. but we will sit down with DCS and kind of go through all of those to see which ones are still active documents that are used, and we can provide those to all of you so that you can actually look and see what the document itself is, what the data points are. Some of them are really just forms that I think you would use to for data entry, if that makes sense. There isn't anything substantive in them at all. But a lot of them are really valuable forms, some of which I've never seen, and they might not be being used on a regular basis, but we can also allow you guys to look at all of those.
If there are a form that's generated in the case, for example, I'll look at the last one, out-of-home progress update. I don't know whether you folks are using that or not, but if that form was used, it's likely that it's where data is input and creates an out-of-home progress report for a case. And that's just the form that is used. Is that a fair way to look at that? And maybe you don't know, but I can see where some of them look like this is just where we're putting information and it's getting saved. And so it's just a form. But it becomes a document in the case when case-specific information is input into it and saved that way.
Yes, that's a good example to point out. So that specific out-of-home progress update is a form that's used during clinical supervision by supervisors. It was also part of a recent process improvement effort to reduce the burden on like the administrative time for that documentation to be uploaded. So I think to the point I think that's being made over here is that these things are going to change over time. We're going to have new contracts. We're going to have new services. We're going to have new documents. So this exercise is going to be something that is forever debated of whether or not they need this new titled document. But this one probably won't exist much longer because there's now people that are going to enter this stuff into a different format for the supervision process. It's an evolving beast. But what I do think, and the point of like immediacy on these initial hearings is important, is thinking about where we want to go next on how we improve this. I tell the team right now, like case notes is the thing. Everybody wants the notes of what actually was investigated and documented. That's the thing that's next. We're going to deliver that by January, and then we need to pick the next thing. So the next thing needs to be of equal high import to those very key decisions early on. And we can deal with some of the other stuff down the road, but we need to pick the top 5 that we all agree are the most important ones and start marching down that path more immediately. And so what I'm thinking in the next conversation, less about going through an itemized list of everything, because that'll be a big burden. If y'all can describe, like, these are the most important things, like plain language, then we can do some of the cross-referencing back on the technology side to say these are the data tables that you need that will meet that. You'll be able to see it in part of the development process, and you can tell us if we got it right or got it wrong, and we can change it and fix it and make sure that what we land with and gets disclosed to everybody is actually what you asked for and what you needed. And we would do these things in relatively short iterative cycles of talking with folks. We've seen some key stakeholders.
And it's a little bit of a chicken and egg because their point is they don't know what data points you have. So until they know that, they can't even help with the priorities. And then looking at, do some of these have to wait, or do we say, look, the green ones just go into the file that they're going to be disclosed, and we move that now that it can work.
So we have a team of folks that are trained business analysts, that their skill is asking questions to folks that don't have technical information and being able to say, I'm hearing what you said. Let me go cross-reference it with what's in there. So you wouldn't need to know it's this data table that contains the households for the family functioning assessment. You would just say, I need all of the stuff that the investigator writes when they're talking to kids. I need those assessments that they write when they put down the CPCs for a family, or when they identify impending danger, that I need that information. And then we'd be able to cross-reference and map it and whittle this list down iteratively, if that makes sense.
But I'm going to put the chicken and egg back out there because they don't know if somebody is taking notes on something, and so they need to know that. So we kind of have to go through what it all is. Then you can have that conversation once they know the universe of stuff that's being collected. And that's always been a bit of there's been a curtain up And so they don't
Sure.
have that information, and I know we're taking a curtain down, and this is a big shift. It's an important shift, and it's hard for the folks who are having to do it. It's also hard for the folks who are saying, I should have had this last year. And I think that's a fair statement in both directions. So, I still think we're gonna have to go through what these documents are, what the data points are. Then the conversation is, okay, with that understanding, you know, let's talk about what you need. And but I think, I don't want to speak for you folks, but that's what I've been hearing. Judge Foster?
Yeah, Judge, you know, and as I look at this list, and one of the things, or a couple of things here, just conjures some memories of a case that Kirsten and I had, where it talks about OCWI audio and video, OCWI images. I mean, we had a case where it turns out that somebody recorded kids, and it just came out in the middle of a hearing, long after the case had begun. And what the kids had said on tape was interesting to the case, and we argued back and forth. And it turns out the kids stayed exactly where they were in the aftermath of it. But once again, I didn't know there were tape recordings. And Kirsten didn't know there were tape recordings. We were like, oh, there's tape recordings. Interesting. You know, and you got 4 kids, and each of them are telling a different story. You know, and yeah, she beat me on that one. Okay, but then at the end of the day, the kids stayed with the parents. So I guess I had a win on the backside. But you know, those are the kind of things when you say we don't know what we don't know is there. And perhaps if that had been at the beginning of the case, we wouldn't have had a whole lot of people doing a whole lot of things they didn't really need to be doing. And so that's why I stress the importance. I've always stressed the importance. You know, one of the lawyers at juvenile court when I first started said to me, he says, I never want to have your job. And I said, why is that? He says, because you have to make decisions about people's lives and you will never have the information you need. And
I sat in that chair too.
yeah. And so we work with what we've got. And hopefully what we're doing here today is working towards being able to get the information that we really need. I don't know that we can do it in this particular forum. Like I said, I'm more than willing to go there or there, come to me, or we meet somewhere in the middle and understand what it is that we really need to be having.
Well, I agree. I don't think we can do it all here, but I think we need to keep coming back here so we make sure it keeps happening, because it's easy enough to not, and I want to get progress, and that's how I keep my finger on it. For example,
let me just say, I'm sorry, I didn't mean to
no,
interrupt
go
you,
ahead.
but I did contact Mr. Abril from their office about getting together once all of our agencies had a chance to see these lists. So we're not sitting on toadstools by any means, just
No.
us, okay?
I didn't take it that way, but you know what I mean.
Yeah, no, I know.
You keep setting
I
a
understand.
review hearing because.
Yeah, I understand. And so what I anticipated today is telling you that we've got the list. Now we've got a new list today. But we intend to go find these things out and try to be able to come back and tell you.
And
what
will we
it
be
is
able to
that-
get that list of the tables out too? Because I don't think that's been I have not seen it that I recall.
Yes, we can definitely get the table, and that might also warrant another discussion through it, just to show and talk it about how this stuff all connects, because it will be a daunting list of tables.
But that's part of it, is that we're at a point where we're doing a daunting job because over the years we haven't.
Yes.
So we're doing what our decades of work, and we're trying to get it done as quickly as possible. And I think there are areas, and I'll just use the tapes that were mentioned. I don't think I'm not sure where I would say that it's not a disclosable thing that there were tapes of the children, ever. That's always something that's going to be relevant, because the lawyer may listen to it and go, wait, there is a difference in what was just said that somebody else didn't pick up on, a subtlety in the case. So I think what we're looking at is that shouldn't have happened to begin with, and our plan is so it doesn't happen again. Here are the tapes, not the tapes that exist, but here are the tapes so that they can be seen. It actually occurred to me, and I hesitate to bring it up, but since we talked about recordings, is voicemails. You know, if, if a parent left a voicemail or something, how is that kept track of or not? And it's something that we may need to look at, but since the tapes came up, I thought, well, I guess I'll throw the voicemails in there because they are recorded. And how those might need to be preserved or not, I'm not going to say that. That's something for folks to think about. Unfortunately, it seems every time we meet, we have a new thing to throw into the pie. It's going to be an interesting jumbleberry pie is what I've heard those called, where every piece of fruit in the refrigerator goes in. So why don't we talk about how we're going to accomplish this? And the problem is everybody has a day job. And somebody has to pick up the task. And it sounds like you folks have some dedicated folks. And do you want the person, and give me her name? She's sitting there quietly, and she shook her head no.
She's like, not me, not me. Well, I was going to sorry, do you want to? I was going to suggest, because we have, like project managers in our office, and we have right now a project plan related to it from our side. And so we could tie in, some of these meetings and all those kind of things and just work it from our end on a project management side. We sometimes will do, and I know this will not work for people here, but internally, like an all-day kind of like brainstorming type event, where if we can get the input and then we can take it back and come up with something to present. I think that might be the best.
Well, and I will tell you from my perspective, when I'm looking at a list of 600, 800, and more than 1,000, this is going to take commitment on your folks' side to go through it. And, and it doesn't seem fair, but at the same time, I think it's the only way it can happen effectively is to go through that and take the time to go through that. Because otherwise we're going to keep going, well, I don't know what this document means or what this is. The other thing is, I think, looking at the formatting, like seeing that table so that folks actually see it as opposed to a description to say, yeah, that actually works. If we hide these 3 columns and lock it down. And this is, in a sense, odd that we're having this conversation, but it's not. This is ESI discussion, where you say, what format do you need it in? Does this format work? And you plan all that stuff out, and then it can run. And so when you get into the large civil cases, that's how you get to see what it looks like and make sure you get it in a format that's usable. Is this kind of legwork needs to be done, but then ideally we can get into every time we come up with a few new documents, everyone sits down, we only have a few documents, and the system runs smoothly. We're trying to set up a system to run that just hasn't run the way it should have for 30 years. So are you folks going to be, can you find the time, because I know you have day jobs, to be able to sit down with them? And I'm not saying it has to happen over the next few weeks, but the sooner it happens, the sooner we get to the end result, which is get this stuff in your folks' hands.
Judge, this is my day job.
All right. And I know you're not speaking for everybody, and I think so does the department, but you are speaking from a knowing perspective. And again, if we can't come up with an agreement on things, then lawyers will litigate that. That's what we always do. But there is a vast world that now folks are recognizing should be subject to disclosure, and that's a good thing. So what kind of time frame would we be looking at to get, and again, I'm looking at deliverables. I want to know, when do we think we can get these meetings set up so we can go through all of this information? And it's going to make your folks' head hurt, I think, to do it. I don't need to be there. It's not my day job. But somebody needs to go through it. What times kind of schedule do you folks think you have?
So we are actively working on this stuff right now. So there are meetings, like yesterday I was in a couple meetings. This morning I was in a few meetings on disclosure-related information on this next step. So they're in flight. So our project managers are actively working. So it's a matter of do we have the names of folks that want to show up, and then we can get invites out to the right meetings. We will likely need to set something dedicated to go through the full list, because that's not currently in the roadmap of things. But we tend to operate on 2-week cycles of work, and once a quarter we plan out the big bites that we're taking in it. We chunk it out into 2 weeks, and we just knock it out and go. So if we know who wants to be at the table, and You got them, okay. Then we can send out calendar invites and make it, in person and virtual for people to be accommodating to the schedules, because it will go pretty short notice, I think.
So to facilitate some of this, could we create a PDF of what the blank documents are? This is just what the documents are that are associated with the table, because I think from their perspective, they don't need to sit and look at them with you. If we can get that out, that you can say, okay, on PDF, because like, for example, there's no number column, but document number one in the attachment, that way you can at least see what it is.
There are numbers in the electronic version. When I printed
figured.
it didn't. And then just so Judge Foster knows, last week I did send you the full list. So there were 2 attachments, the full list, and then the list I gave you today is what we've condensed down and pulled out of the full list, just so that you're aware. If you want me to resend, I'm happy to resend. Okay. Yep.
So would it help you folks to get that, a document that's tied, and I figured there were column numbers, it's just they're off to the side, that it says row number 1 is the client-related document assessment report, and then they give you whatever document is associated with that. So as you're going through it, you come into it with a little bit more knowledge.
If I could propose something,
Sure.
that within, like next Thursday, that I contact Kirsten, about the various documents, have an initial discussion about what's what. By that time, I will have talked to at least the people in my office, perhaps some of the other offices, about what do you want to have at the inception of a case right away. We can identify those things and move in that direction, such that we can get these things timely and within the rules. Does that make sense? So that by Thursday we'll have met about that, and you have holidays coming up, and I'm sure nobody's working Thanksgiving week. Of course not. So you'll either have to set, if you want to.
I'm sorry, you're sure?
Except
I do have a day job.
those dedicated members of the appellate bench, I'm sure they never stop working.
I will be here. I'm not going to go beyond that.
Well, and so the either before that Thanksgiving week or after would probably be a time to come back and see you.
And so, and I want to make sure the timing before the Thanksgiving week or after. And so I had used November 12th only because that's 2 weeks from now. That is 2 weeks from now. Is that okay? Or would you say, no, let's push it out one more week? That's still not Thanksgiving week. That's still the week before.
I think especially since we're going to be doing, I think, quite a lot of meeting, I think that extra week would be helpful.
So if we used, is it the 19th? Only, my computer locked up. So if we use November 19th, again, I still want to talk, and we'll have part of that meeting to talk about the special actions, because I just think that's an important piece for this group. To come back then, that you folks will have met, and we'll at least have a little bit better of a framework. You'll have a lot more information at the end of that to be able to at least give some direction. As I understand it from Mr. Hinsey, we're on track for the case notes for January. And there may be other parts that can also be part of that January, depending on the block. Is that fair?
So at the moment, it's case notes. If that goes better than we think, then maybe we can throw something else in before January. But right now, it's case notes, because it's a 0 to 1. It's brand new stuff that we're building out there. So it's to the point of the unknown unknowns. Like, we're coming into some of those things in the development.
And I understand that. And again, this is where we're in just a different place for the other folks in the room, that in the past, this was never even on the table. While it may be frustrating that it's going to take till January to get it done, they're doing it. And we're going to have that. That doesn't make it feel better for somebody who in the past didn't get those case notes. I understand that. But I think it's really important that as we go forward, we're not going to have that problem. And that'll be case notes on existing cases too, so old case notes. It'll be all the case notes for cases that are going on. And that's part of what we're trying to grapple with. All
Well,
right.
and can I just clarify one point?
Yeah.
Because they are disclosing case notes now. It's just not in the automated process that Stephen's talking about. So you should be seeing more of those coming in. And if you're not on a case, you can elevate it to me. Or
And
Christy.
that's
Elevate
why-
it to Christy, sorry.
And I should say that history is, that's a relatively recent change, but it is happening. And we're trying to automate it so it's not slowed down because you need a person's hand to do it. All right. In terms of today, is there anything else that we can do today or need to talk about today, except to introduce your person, because I do want her to introduce herself, because I got the impression you're not quite as new, at least to this, as Judge
Well, I
Foster,
hope
the way
it's
you
not-
looked.
I hope it's not by just looking at me and how old I am, but no,
No.
Your Honor, my
It
name
was the expression on your face.
Thank you. My name's Christy Shelton. I'm the Assistant Director for Field Operations. So Ms. Wright said new. Yes, new to this role. I was with the department for 18 years, left for a bit of time and have returned. And so I'm familiar with our friends across the table here. I did want to say and want to express my staff, field staff, understand the importance of this, and they appreciate the urgency and know the obligation for disclosure. We do track it. As we've talked about, we've got reports. I can tell what regions, where they're at with certain things, and so we do use that to help drive behavior and understand where to do work, right? Because when you look at a big pile, it's where the heck do I start? And so we have the tools to give them a place to start. And we do, again, we understand the importance. We want to make sure that we are compliant with this expectation while we're doing all the other expectations that our field have. So please know that we do take this very seriously, and we do monitor it, and we are working those piles down.
I think that's the challenge is it became one big pile because for too long it was just thrown into one place. It now is getting sorted out so that we can say, okay, these are the piles that, and probably not piles, but should be little mounds in each case that we keep moving and move them along. All right. So then let's plan, can we make sure we reserve this room for 119 for the 19th? Okay. I think this room works well. We'll make sure we have the microphones. Did the people here, were you able to hear us this time? Is that a yes? Okay. I'm getting some blank stares. Okay. If that's the problem, then wave if you can't hear. I will tell you, I'm not going to hand you a microphone because of the way we're doing this, but if you can't hear, please wave, because we don't want you sitting here wondering what we're saying. We want you to be filled in on it. I appreciate, again, what the department is doing, that there has been a sea change, I'm just going to call it that, in how it is being approached. That is a good thing. I appreciate this side. We need to make sure we keep getting that information out. Think about what are the other pieces to this that we haven't touched on, so that we just don't finish this and then go, and then we forgot about that. There's probably something on both sides that you're thinking, what about this? Could we do this? Let's just really have that conversation, because if we get into it, I think we're all going to leave this in a better place, and hopefully the system will function better. So on the 19th, then we'll be back. I will have, I think Judge Andrews is hoping to be here, perhaps Judge Howell as well. We just did that presentation yesterday on this special action thing, but I think it's really relevant to you folks for dependencies. Well, we don't get many. Maybe we'll get more because of this. But for a review, especially for your clients, I think your folks want to pay attention to how you may be able to get this in front of us in a more meaningful way and get a meaningful review. So anything else for the good of the order that folks want to add? Ms. Wright?
No, I just want to thank everyone for being here. And one little thing I would say is please give the case managers a little grace, because this is a big change for them. And we've had some case managers saying that they're just overwhelmed with disclosure and they're struggling to get out and see their kids. And so I just want to keep in mind that this is a huge change for the department on some levels, and they're doing their absolute best to make sure that they're in compliance. So reach out to your AGs. let your AGs know if you feel like you're not getting something, and we can kind of work from it on that end. But I do know that the field is very diligently working to comply.
And I appreciate that that is a very difficult job. And they care. They're there because they care. Many of them could go make more money elsewhere doing something different. And it is a hard job. We still have to do it right, and that's the important thing. But there is a lot to be said for kindness. The sign in my office is because nice matters. You know, that is true. And kind and nice and good are three different things and need to be recognized as such. But I think we can work through this. I think we can get there. Our concern, and the reason time is of the essence, is every kid in the system right now, every parent in the system, is a little behind the eight ball. And we need to not lose sight of that, which is why we need to keep working and getting this done as quickly as possible for folks. So please, from my perspective, extend my appreciation to all of the caseworkers, because I know that that is a tough job, and I've known people who have done it. And to the parents who are living through this and the children, this is a tough thing all the way around, and we're dealing with people's lives, and that's why it's so important to be here and having this conversation. Did you folks want to add anything? I don't want to not give you the last word. Judge Foster, you're always good at the last word. I'm surprised.
I'll just tell you what I told people since I retired. I've never been big on titles, and people might get confused if you keep calling me Judge. You can just call me George.
In meetings like this, you're welcome to call me Dave, because I'm not here as a judge. I'm here in that sense. I'm not wearing the robe. But in a courtroom, don't try that. It does not play well. I have watched lawyers try it, and it just falls flat. And I've been called a lot of names besides Dave, too, but that's a story for a different day. Thank you, folks, and let's keep working on this. Judge Young, before I sign off, did you have anything? You can just wave no.
No, I appreciate you convening this again.
All right, great. We'll see you folks on the 19th.